Your Honor,
Yes, sir.
um, I had a problem earlier, understanding what was going on. I'm gonna put it on video now because I know originally, because I'm at work and my job's being
Okay.
kind of let me handle this matter.
What's
You
your name?
just Demetrius Roberts. I didn't understand anything that just happened.
All right. So, Mr. Roberts, you missed a court date when they were asking to have your bond revoked. And because of that, a bench warrant was issued. So the bench warrant is still there because you were supposed to come into court, not
Why
appear by.
do I have a bench warrant, Your Honor? I was under understanding that
Mr. Roberts,
my
if
court.
you will listen, I just told you why you have a bench warrant.
You said I do or I don't?
You do. I just told you why. You were set, you had a hearing set for a bond revocation. When we came to court to bond revocation, you did not show up and your attorneys had not heard from you. You did not have a legal excuse. Therefore, a bench warrant was issued. This next time you came to court, you came by video as opposed to coming into court.
Um, Okay. Well, I did notice something that the courts have the wrong address, and I remember.
No. Mm-mm.
Go ahead.
That's a narrative we're going to change. The courts
Okay.
have the address that we have for you. If you have moved or you have changed your address, then there's no way for us to know unless you tell us. And it is the defendant's responsibility to keep your address updated.
Well, that's what I was trying to explain, Your Honor. That address was an address 25 years ago, so I don't even know how that's even possible. See, I think you guys got 6181 Harkins Court. That has been my address for like 25 years, or if not longer.
So,
I didn't
Mr.
have kids with that address.
When did you come in and tell us we had the wrong address?
Well, when I was arrested at the time, I'm assuming that with the information that was given, that they had the correct address. There's no way I would have
Why
missed
you
my court
assume?
date. Okay. I remember originally I was supposed to be in court also, is what I was trying to explain. And I remember for some odd reason your court dates got canceled. So
Not the
this
one where you had a motion to revoke your bond. That one didn't get.
Okay. I'm sorry.
And
I didn't know.
Mr. Roberts, the other part is if you were keeping in touch with your attorneys, even if you didn't get the mail, they do.
Right. And the only way I found out about this matter is when my bail's bond and called. I mean, I have full intentions with cooperation with this matter. I would not miss a court date, is what I'm saying. So I didn't intentionally try to miss a court date. I was unaware of the court date, is basically what I'm saying.
Okay. So you are currently entering a plea of not guilty on all three cases. So
Correct.
your cases will go to trial, but you still have an outstanding motion to revoke bond for which you did not appear. Therefore, a bench warrant is still in effect.
What can I do to get the bench warrant removed, y'all? Is what I'm trying to understand. I'm here at court. I would have just came, but from my understanding, I just started a new job, so that's why I did this. So other than that, I would have came to court today.
You and your attorney, you need to talk to your attorney and y'all can work it out.
So I still have a warrant. What can I do to resolve the warrant? I can't. I understand.
You need to talk to your attorney and y'all need to work something out.
Who is this, Your Honor? Is this our client?
No, yeah, it's Mr. White's client.
Oh, okay.
Is my attorney still there?
Yeah, he's there. He might be outside the courtroom talking to somebody else, but he's still there.
So right now it's like I'm a fugitive. So basically my lawyer, I'm at the mercy of my lawyer. My lawyer's going to tell me how to handle this as far as dealing with the warrant. There's no way you can lift the warrant.
Talk to your lawyer first.
All right. Thank you, Your Honor.
You're welcome, Mr. Roberts.
I do have a question. So everything has to go through the attorney. So there's no way you can get a warrant lifted. If you miss a court date, there's no way to lift the warrant. If you have my full cooperation.
I can lift a warrant anytime I want to. What I'm telling you is you need to talk to your attorney and get this worked out because you missed a court date for a revocation of bond. That tells me that there's allegations that you did something against your bond orders. Don't talk about it. Don't tell me about it, but you need to discuss that with your attorney because I need to have a hearing about what that was about. So there's an allegation that you violated your bond conditions. And for that, the state wants to revoke your bond and put you in jail. missed that hearing. Now you need to talk to your attorney and either work it out so we have another hearing or something else.
Okay, we have another hearing concerning the actual charge. Is that what you're speaking of, Your Honor?
Yes, sir.
Okay, so I have to talk to my attorney to get this resolved, babe. Okay.
Yes, sir.
It's very hard to get in touch with him. Please can you ask him to get in contact with me, or can somebody make sure that he calls me, please?
Ms. Hahn, if you will make a note to have Mr. White contact Mr. Roberts.
Yeah.
Your Honor, Mr. White is in here with me, so when he's done,
He'll call you. He's
Well,
talking to the state right now. He may be working it
yeah,
out.
this is very serious. So I really just understand, Your Honor, this is my freedom, and I have an employer. I don't want nobody coming up here disturbing this company or anything. Like, I have my full cooperation to deal with this matter. I just want to know what I need to do to resolve this. So I'm sure you can have some compassion and understand that.
Roberts, we're gonna.
So I just want to get this taken care of, like right now, like while I have time to have it.
Mr.
Hold
White is
on.
going to call you. He understands the importance. He's going to call you, but there's nothing that he can do while you're talking to the judge. So if you could just give us a moment and then he'll call you, okay?
Please, thank you. Thank you, guys.
All right. Stop interrupting, ma'am.
Oh, no, I'm sorry. I didn't mean to interrupt. I'm going through TSA. I must have unmuted my phone. My
Okay.
apologies.
No problem. All right.
Court is calling 2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense?
Andrew Frederick, Ms. Lockhart.
Are you Ms. Lockhart?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, sir.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying, yes, sir.
No, I said yes, Your Honor.
No, you said, yes, sir.
Said yes, Your Honor.
I would
Okay.
say I heard yes, Your Honor, as well, Judge.
Okay. All right. Are you proceeding on
I
then?
have 1 moment.
Are you proceeding on the indictment as presented?
Judge, we're gonna go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, I whispered to her that she needs to speak up and not say it. So yeah, no,
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that and I'm like, what? All right. Did you understand the state is proceeding on the lesser included offense of attempted arson, recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge,
I believe, Judge, since it's attempted, the arson recklessly causing damage is a state jail, and since it's attempted, it's a class A misdemeanor.
Okay, why do you guys have this filled out as a state jail?
It should have been
the
changed.
first paragraph specifically should list it as a class A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork.
Judge,
That way you can write it in because otherwise
it's difficult.
I don't have knowledge that she knows that it's a class A because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, and it says range of punishment, and it listed up to a $4,000 fine and up to a year in jail.
Oh, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
That's no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know, okay? All right, so this is what I'm gonna need you all to do, though.
Yes,
I
Judge.
need her to initial it, so I know that she knows, because all of this is state jail felony paperwork. That's why I say
Well,
state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. Or from now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to look like.
Yeah, we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be. All right. All right, so we're back on the record. All right, they're charging you as arson as a class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in a Bear County jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court only has the authority to sentence you up to 1 year in the Bear County jail and up to a $4,000 fine?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree, she is competent.
All right. So she's already been to the magistrate's court and they've deemed her competent?
That's correct, Your Honor.
All right. Do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Lockhart, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. According to the plea, the state is proceeding on the lesser included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 634806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand?
Yes, Your Honor.
Okay. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right. Then to the offense of attempted arson recklessly causing damage, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer state exhibit 1 and all attachments.
No objections.
All right. I'm going to show you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Sure.
Anything you wish to say on behalf of your client?
That's the follow the mark.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 North.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought me.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out why were you homeless and why would your father let you live with him now?
Judge, if I can just have a second.
Here's the thing, Ms. Lockhart, you need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bear County Jail. They're going to do a PSI report and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant,
Okay, I just wanted to hear it. And how far along?
like 21, 22 weeks now.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside of it, but she understands she's going to take the parenting class going forward. Because that's going to be her.
All right, and is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins? That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm gonna sentence you to 2 years deferred adjudication. I'm gonna want felony drug court referral. They should be able to do it because it's 2 years. And I'm gonna want a MIC evaluation. Those are to take place while in custody. And then I'm gonna want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's something else she needs, Judge. We asked the evaluations be done when she's out in custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, yes.
All
Your
right,
Honor.
because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time,
Mhm.
we've conferred with the DA, and this is the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All right.
She was approved. I know that she's being evaluated for mental at the MIC caseload.
Mhm.
Being that it's a misdemeanor, but mental health court, I don't think that was approached because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
That's what I was thinking ahead, Judge. And that's why my brain was going like, I don't know if it looked like I was rolling my eyes. But I was like, does that mean that she wants? Yes. Okay.
All
I'll
right,
explain that.
so,
Thank
LaShawn,
you.
if you can, you're welcome. LaShawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they're willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day.
And I'll explain in a second what she's doing and really helping her out. But,
All right, and they'll put you back in the box so probation can speak with you, okay?
Yes, ma'am.
All right.
Thank you.
Mario, you're welcome. Mario Miranda.
Parties stated that they had gotten into a verbal altercation, Mr. Carpenter and Miss Carpenter. I basically asked, because, you know, an argument is an argument. I asked Miss Carpenter, okay, basically, why did you call us here today? So she said that based on the actions of Mr. Carpenter, she felt that he was going to hurt her. Now, based on that, her saying that he had his fist balled and his shoulders raised, causing her to have to run to the other side of the bed, Mr. Carpenter was arrested for simple assault, basically placing Mrs. Carpenter in fear of receiving immediate bodily harm.
And at that time, did you have the opportunity to speak with the defendant, Mr. Carpenter?
Yes, before placing him under arrest, of course, I did speak with him. He stated that he did enter the bedroom. He was, you know, arguing with her. He stated that he did not touch her. Like I said, nothing physical happened other than an argument and Mrs. Carpenter being placed in receiving immediate bodily harm.
And at that time, after you had spoken with the defendant and the victim, what determination did you make?
I made the determination that Mr. Carpenter had to be arrested for simple assault against Miss Carpenter.
All right. And did you arrest Mr. Carpenter?
Yes, ma'am, I did.
Thank you. No additional questions, Your Honor.
All right. Cross-examination.
No, Your Honor.
All right. State may call its next witness. May this officer be excused, or is she subject to recall?
She can be excused. Thank you, Officer Nimmons.
All right. Officer Nimmons, thank you. State may call its next witness.
The state would call Miss Carpenter. I'm not sure. She said she was boarding the planes. I don't know.
She said she was going through TSA, I think.
Oh.
Miss Carpenter?
I'm not boarding now. I just got through TSA. I'm trying to figure out how to, I don't know if I need to cut this camera on. I can't figure it out. I'm just all discombobulated. So I'm sorry.
Are you sitting down?
I'm walking actually to my gate.
Okay. So yeah, you need to turn your camera on.
Okay, let me
look at your phone.
if I can figure it out.
Do you see something that looks like an old-fashioned video camera? Like an icon that looks...
Yeah, I see it to turn the camera, but I don't see anything. And there's something coming up about me turning my screen, keeping it clear, but I don't see.
Okay, listen to me. Touch your screen next to your name, and you should see 3 dots. So you don't see the 3 dots at all?
I don't know if...
There you are. All right. That's fine.
Okay.
Okay. Now, all right. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. You put your hand down. Ms. Janvier?
Thank you.
Are you able to sit down or stop?
I can hear you. Well, I don't want to sit down and stop until I get to my gate because I don't want to risk missing my flight. So I mean, I'm walking to my gate now, but is the noise a distraction or?
I hear him pretty clearly. Let's see if we can go on.
Can you state your name for the record, please?
Cassie Carpenter.
And Ms. Carpenter, what is your relation to Patrick Carpenter?
I'm his wife.
And how long have you been married?
We've been married for 9 years.
And Ms. Carpenter, did you call the police in reference to a domestic disturbance between yourself and Mr. Carpenter prior?
I did.
Do you recall?
I'm sorry, I cut you off.
Do you recall approximately how many times you called the police regarding altercations with your husband, Mr. Carpenter?
I don't really know if I don't know if a number off the top of my head. I mean, it's probably been about 3, maybe, that I can think of just off the top of my head. And
excuse me, additionally, Ms. Carpenter, were you aware that after the incident occurring in February of 2021 that you were not to have any contact with Mr. Carpenter?
I was not aware until recently when I spoke with someone on the phone.
And are you currently working?
I'm self-employed.
And to your knowledge, does Mr. Carpenter work?
Yes. He also, I guess you could consider it, I don't know if you would consider it self-employment or not, but yes, he does work.
And is Mr. Carpenter the primary breadwinner in your home?
At this moment, yes, he makes the majority of the income.
Do you and Mr. Carpenter have any children together?
We do.
Okay,
we have 3 total. We have 3 total. One, two are my stepchildren and 1 between us both.
And do they live in the home with you all as well?
2 of them live in the home.
And are you primarily responsible for the care of those children?
Yes, ma'am.
And do you rely on Mr. Carpenter at all to assist you with caring for those children?
Most definitely. It's a team effort for sure. We went from having one child in the home to having my stepdaughter come down, which has been a challenge for us both. So yeah, we definitely work together.
And would it be fair to say that you don't really wish to testify against Mr. Carpenter today?
Not at all. I'm only here because I don't want him to be charged for something that Patrick is not a violent person. You know, we argue like regular married people. If it gets too heated, I call, like, my thing is to call just to mediate if nothing else, because I never wanted to get to that point. Not saying that my husband will cause me any physical harm, but a lot of people think that all the time and they just blow things off and things happen. So when we get in heated arguments or heated discussions, to assist us both, I usually reach out to the police to either, help calm the situation down or ask him to, leave the home temporarily or whatever the case may be, which has been done in the past. So, that's what I expected to happen. I didn't expect it to be, to this extreme. And like I said in my statement I sent out, I do feel like, we both learned from it, because now, if we do have a disagreement, it doesn't get to that point because neither one of us want it to escalate to where, either of us feel like we need to get the police involved, because, this has just been a lot. It's affected our lives in a big way. So.
In February of 2021, when you called the police to mediate, was the defendant, Mr. Carpenter, was he arrested at that time?
2021. Where? I want to say he was. I believe that was Brookstone. Yeah, I want to say that's the incident where he was arrested.
And do you recall what occurred at that time?
I believe that the officer who just made a statement, her as well as another officer, came once they were called out. And this is the correct incident I'm thinking of. They came in. The situation had already, I guess, kind of calmed itself. Patrick had ordered a ride share to get ready to leave. And so it was already kind of calming down. We were both still upset though. So when they came in, we were, both telling our side to the officers and, kind of like going back and forth. They were kind of mediating, which was what I wanted. And everything kind of calmed down and it seemed cool. We started talking to the officer about, different discussions, like my business and our pets and things of that sort. And then that's when they came toward him and said that they were going to be arresting him for the charges listed.
So that was the incident in 2021. And then you called the police again in 2022, because again, you had been in an altercation with your husband. Is that correct?
Okay, so I'm probably mixing up the incidents. The most recent incident is when he was arrested. So I don't know if that was 2021 or 2022, but I think we were at two different residences at the time. So I'm probably mixing up the two. But I believe there was one incident where I don't remember if he was arrested that both incidents or not, honestly. I want to say once he wasn't and the other one he was, but he might have been arrested both. I don't want to give you the wrong answer because I really can't recall. It's a couple of years ago.
All right. Just one additional question for you, Ms. Carpenter. Is it fair to say that you love your husband?
Oh, most definitely. I mean, he drives me crazy, but but that's normal. It's in a normal way. Yes, I do. I love Patrick. I wouldn't have been with him for 16 years, married 9 years if I didn't love my husband. So.
Thank you. No additional questions, Your Honor.
All right, Mr. White.
Good morning, Ms. Carpenter.
Yes, sir.
Ms. Carpenter, would it be fair to say that you are not afraid of Mr. Carpenter?
No, I'm not afraid of Patrick. I'm not afraid of Patrick. not something that he's not something that I fear at
And would-
all. So
Would you like to continue to have contact with Mr. Carpenter?
I mean, most definitely. Like I said, we raise kids together, we pay bills together. At this moment, he's the primary income, so it will heavily affect my, my life and the upbringing of my children if, we can't be around each other. I mean, it's almost impossible to work together and raise our kids if we can't have any contact. So, because of our past mistakes. So, yeah, most definitely would not want that.
Okay. And in between the 2021 incident and the 2022 incident, did you and Mr. Carpenter move?
I believe we moved, yes.
Your Honor, I have no further questions.
Anything else from the state?
No, Your Honor.
All right, does the defense have anything to present?
No, Your Honor, just argument.
All right, make your arguments.
Your Honor, in reference to the actual bond order that the state submitted, one thing I would like to bring your attention to is the fact that Mr. Carpenter actually never signed the bond order.
Nope, no, sir. Not gonna do it. Because if it was a pandemic, they weren't signing paperwork. And even if it's not, if I've done first appearance, that's why I know it upside down and inside out. Most people don't sign their bond conditions, but those bond conditions are read to them in court and they're given a copy of the bond conditions. And if he got out on bond and he's not aware of what his bond conditions are, then he's the dummy. Because I'm not going to not read something that's affecting my liberty.
Yes, Your Honor. In
So
regards
go on to your next argument.
Yes, Your Honor. Your Honor, as you heard from Ms. Carpenter, in reference to the actual thing when looking at revoking a bond, of course, you have to consider whether or not the defendant is going to intimidate the witness, whether the witness is going to be intimidated. As Ms. Carpenter testifies, she's not intimidated by Mr. Carpenter. She would like to still have contact with him. As you can see from the fact that Mr. Carpenter is here in court, despite the fact that there is at least a chance that he could be going to jail today, he's clearly not trying to run from the situation. He is clearly not a flight risk in the situation. And even if you find that the bond condition has been violated, you do not have to actually throw Mr. Carpenter in jail. You can add extra conditions to help impose the fact that this situation does not happen again. One thing I can potentially recommend is, due to the fact that, of course, these cases are family violence, an extra condition of the bond could be that he be required to take a family violence intervention course, as opposed to actually throwing him in jail. In addition, Your Honor, as you can clearly see, Ms. Carpenter is prepared to go on a flight right now. As she stated, they do have children together, and right now Mr. Carpenter is the only one who can take care of them at the moment. So if he were to be arrested today, then there would be no one to go and take care of the kids. So
well, she's putting a lot of trust in what decision I'm gonna make, because she already at the airport.
I'm on my way back home, actually. Like I was out of town for my mother's 60th, and then that's when I was notified of the court date. So I'm just trying to be here however I can be here to help the situation. So
Ms. Janvier, you got anything?
Yes, Your Honor. So the state would contend that there has been a violation, clearly, of the bond condition to stay away. The defendant, the victim herself, is advised that they continue to live together. He is the breadwinner in the home, and that they are raising the children together in the home. The state would point out to the court that there are two cases which involve the defendant and the victim. She is the victim of both cases, and although the victim is advised that she may not have any fear today, it is evident that on both occasions she had concerns for where the victim's anger or would lead him, or where his actions would lead him, as to whether or not she was safe at those particular times. Additionally, Your Honor, the fact that the defendant has violated the bond conditions would show that he does pose a risk to potentially committing a felony at any point between now and actually being heard on these cases, and that it does pose a safety concern to the community, as the wife that he has been with for, I guess she said 16 years, has called the police on multiple occasions, so many occasions that she is confusing the occasion, doesn't know which ones at which time she's called. At this time, the state would say that the defendant has violated the bond conditions and that his bond should be revoked.
Mr. Carpenter, come up here to the computer so I can see you and look you in your face. Ms. Carpenter, I'm gonna need
Yes,
y'all.
ma'am.
I just learned this because I'm old, but I pay attention. I'm gonna need y'all to take us off the group chat. I'm really gonna need y'all to take us off the group chat. The police are not here to mediate your situation. Don't keep calling the police because you want somebody to talk y'all down and to make your marriage work. That's what therapy is for. But stop calling us, because this is getting ridiculous. Well, I call him, but I don't want him to go to jail. Well, I call him, but I don't want y'all to do anything to him. You are wasting our time. And I'm just going to be honest about it. I take domestic violence too seriously to get caught up in y'all's little wrapped up thing. I love him so much, but he wasn't going to do nothing to me. But I just wanted to call the police to moderate the situation. Police don't moderate. They're going to come there. They're going to figure out what's happening. But you heard that officer say domestic violence is one of the most unsafe situations that officers find themselves in. Because as soon as they show up on the scene, 5 minutes ago, you were calling them because you were scared and he was threatening you. The next thing you know, you show up and y'all both aggressing the officers. Don't take my man. Just take us off the group chat. Y'all get some counseling. Because we're not here to mediate for you or manage your relationship. We're not here for that. Most police officers got situations where somebody's life is in danger. And y'all calling us to mediate. Well, I just call him because, you know, I love him, but we was having an argument, and then get counseling. In fact, that's what I'm gonna order. I'm gonna do exactly what Mr. White said. Mr. Carpenter, you go into family violence counseling. You are going to attend family violence counseling. Now, whether y'all decide after this case is over to attend something together, but you're going to counseling, and the no contact provision stays in place. So no, I'm not modifying it. I'm irritated right now because I really feel like y'all are using the system the way it's not supposed to be used.
Oh, man.
If I truly hush, because if you could work this out, I wouldn't be here. You wouldn't be in my courtroom. If you knew how to have a discussion with your wife that didn't end up with the police coming on at least 3 occasions, I would not be talking to you. So nothing you say to me is going to help. We clear?
Yes, ma'am.
And you're going to take that class. That's what you're going to do. And I'm not modifying anything. Any more contact y'all have together other than paying child support for them kids or sending money to the house for those kids, then all bets are off. Both of y'all, you lose that good job. I'm not playing. But stop calling the police to moderate your situation. That's what therapy is for. And I'm talking to you too, Ms. Carpenter.
I hear you. Can
If
I
y'all
ask you a
been together
question?
9 years, no, listen to me. If y'all been together 9 years and y'all still don't know how to talk to each other, if y'all been married 9 years and you still don't know how to talk to each other, y'all been together 16 years, you still don't know how to talk to each other, and y'all have 3 kids are in this situation, go to family counseling. Figure it out. But the police ain't here to counsel you. I'm clear. And Mr. Carpenter, you're going to end up in jail and you're going to lose whatever livelihood you got if you don't figure out how to walk away. When the argument gets heated, walk away. But what we don't need is you to keep calling officers in here to modify or moderate your situation. That ain't what we do. That's not what they do. So now, Ms. Carpenter, you had a question.
Yes, I did. Well, for starters, I want to kind of piggyback off what you said. You know, I might have missed. I don't know if me saying mediated situation made it seem like I'm just using officers to be my counselor, because that's not the case.
You telling us, well,
If,
I'm not scared of him. I want him back. I can't remember how many times I have called the police. Oh my God, but I love him and I want to work with him. This is not what we're here for.
okay, so to my question, if we are, if the order is still in place, how are we supposed to move from this point on? Because we currently reside together. I can't just,
Ms.
move out with
Carpenter,
my kids.
Once again, you're asking me for therapy, and that's not what I do. What we do is separate people when there's a situation that is volatile, and we make that situation safe. And then what we do is we determine if there's someone who has committed a crime. And if that is the case, then I deal with the adjudication of the crime. And so the police are like first responders. All they're there to do is to make sure that they assess the situation. If there's a criminal act being taking place, that they deal with that and they keep people safe. That's what they're there to do. When it gets to me, I'm just here to adjudicate the case. So the two sides, the defense and the state, will come before the court, and either they're going to have a trial or they're going to have a plea or they're going to figure it out some other way. But my job is not to counsel you and work out how y'all going to deal with your kids, because y'all could have been in counseling years ago and figured this out for yourself. So no, that's not my job. What I know is,
I think you misunderstood.
When a bond condition is imposed, that means there's no contact. And if I'm going to keep putting stuff in writing, but if people keep failing to read it, because at any point prior to this point, prior to 2022, February 28th of 2022, if y'all had a situation where y'all felt like the bond condition needed to be modified, it could have been modified. But instead of that, y'all just decided we just going to keep dealing with each other because we don't pay attention to the written word that says Mr. Carpenter's not to have contact. Read, people, read. My supervising judge, when I was a magistrate, she used to say to me, read, judge, read. Because everything you need to know is on those documents. That's why you have bond conditions. And not only do they tell you to read them, there's a judge who tells you at first appearance, look, you're not to have contact with this person. Did first appearance for 4 years, so I know. So Mr. Carpenter, if you were goofy enough to not read your bond conditions and still go back, that's on you, sir. But I don't want this situation where y'all are using us. Go to counseling, but not right now. Mr. Carpenter is going to counseling because there's going to be a new bond condition for him to take the family violence intervention course. Miss Carpenter, I don't know what you're going to do, ma'am, because that's not my job. Managing you is not my job. Managing your relationship, not my job. Managing what's going to happen to your kids because you keep calling the police, not my job.
That was literally a year ago.
What's your point? It's not resolved.
I mean, you okay, that's understandable, but you guys are acting like we've been together 16 years and it's 2 incidents where he went to jail. Like y'all acting like
actually
we call the police and we just have
what I'm hearing was 3
to counsel us. That's not the case. That's just not the case. I just feel like it's being exaggerated, but okay, Judge.
Well, ma'am, I've been married 15 years, been together with my husband probably 19 years, and we ain't never had to call the police. So
that's a blessing.
No, it's intentional. We know how to act. That's just it. So I don't know what's going to happen with you and your kids and all of that, because that's not my job. But what I'm saying to you is, the one thing I'm going to do to help you is not put Mr. Carpenter in jail right now. Because I fully see this is an effort. This is a collaborative effort between the two of you. But Mr. Carpenter, the bond condition stays in place. Mess up again if you want to. So you and your client, your attorney, decide whether we're going to try this case soon or whether y'all going to resolve it some other way. But I'm not playing. I'm not playing these silly games. I'm not here to figure out what y'all gonna do with your children or what y'all gonna do with your relationship. Really, that's not my job. All right, I'm done. All right, we still got a whole nother calendar to hear. Is there everything that we had Dickerson? Is that still the outstanding case on the calendar? What are we doing with Dickerson? Okay, crickets.
Hey,